Thank you very much indeed, Nora, and good afternoon to you all. It's a great pleasure, a great honor to be here after quite a long absence, but it is an important time in the future of the European Union and in the policy area which I deal with in the Commission in Brussels. It's in fact an important week. Because on Wednesday, not only all the politics that's been going on recently, but on Wednesday, the Commission will issue its proposal for what should become the Stockholm Program in December. A lot will happen between now and December. In fact, a lot will happen here between now and December as well, I hope. But what will happen under the Swedish presidency from the 1st of July will be a series of debates, public, parliamentary, within the Council of Ministers, with civil society, based on, we hope, the Commission's proposal, but we have no illusions the proposal will not end up endorsed fully in the Stockholm Program. And at the European Council, at the end of the Swedish presidency in December this year, we hope the European Council will adopt this program. We also hope, of course, that the Lisbon Treaty will be in force or about to be coming into force as well by then, and the Lisbon Treaty will make some aspects of the implementation of the Stockholm Program easier, more accountable, more democratic, more enforceable, and I'll come to some of the details of that in a minute. But why do we have, sounds a bit old-fashioned, why do we have these five-year programs? 5-year plans? Well, the simple answer is that they have worked. They have proved extremely successful in the past. This policy area, which has various names, by the way, Justice and Home Affairs. My DG is called Justice, Freedom and Security. The treaty speaks about freedom, security and justice in that order. Not much actually turns on all these various names, but the policy area generally is a relatively new one in the life of the European Union. The early treaties, Rome, said nothing on this subject. It has grown very much in the last decade, essentially. And it has grown in the last decade through treaty changes, but above all, from a policy impetus point of view, through 2 5-year programs, Tampere in Finland, 1999 to 2004, and The Hague, 2004 to 2009, which brings us, of course, to the end of this year. And so we believed that it was, again, a good idea to seek direction and guidance from the highest political authority of the European Union, the European Council, the heads of state and government, to set out a course for the next period, and that is what we are now embarking on. How did we get to where we are today before looking to the future? Of course, it is easy to look back and say that everything that has been done was inevitable, was a logical consequence of other things that had been done, and that's an optical illusion of history. But I suppose, without simplifying too much, one can say that once the European Union got serious about a single market, a single territory, moving from the early promise of the common market into the serious business of making it work in the 1980s and 90s, and began pulling down barriers to movement between our countries, it became necessary to worry about the external border, because once people moved around. We understood that from the very beginning in respect of goods, which is why we had a customs union provided for from the outset of the old European Economic Community, with a common customs tariff and all the customs system that goes with it. For people, it became obvious later on that something of that order needed to be done. So we have an open territory between us with differences, Schengen or not Schengen. I had to show my passport when I arrived here this morning. and you do too when you come to visit us in Brussels. But Schengen or not Schengen, we have free movement of people to a very large extent achieved between our countries, which means that we have a common responsibility for what happens at our external border, which means Dublin Airport, but also means the border between Poland and the Ukraine, or between Finland and Russia, and so on. And it means that we have to organize exchanges of information and systems between ourselves, and that leads, of course, to police cooperation, it leads to judicial cooperation, it leads to mutual recognition ideas for judgments and other steps towards judgments in judicial proceedings. So all of that brought together gives you, with ups and downs and very odd what we call in Brussels variable geometry, with some countries in Schengen, some not, some opting in, some opting out. That's not going to get any easier, I suppose, in the coming period, but we've learned to live with that. We have today a system with the beginnings of a common set of policies on immigration and asylum, systems providing for mutual recognition of judgments from one legal system to another in full respect of the specific characteristics of our different legal systems, information exchanges between our police and law enforcement authorities, and a common set of rules applicable, at least for the Schengen countries, to their common external border, a common visa policy, and all of that. And that is where we've come to today, in a legal environment characterized by the pillar structure of the European Union, which sees today still most of judicial cooperation and all judicial cooperation, police cooperation in the criminal law field subject to the rule of unanimity, whereas civil law, immigration and asylum have largely moved into the area of qualified majority voting in the Council and co-decision between the Council and the European Parliament. There are some exceptions. In fact, there are many exceptions. Family law is and will remain subject to unanimity, and there are various vestiges of the third pillar, and indeed some new developments to recognize the intergovernmental nature of some of the third pillar issues, which would remain in the Treaty of Lisbon. So that is where we come to today. The question is, where do we go next? Well, obviously, the 5-year period on which we're about to embark is one full of uncertainties, perhaps even more full of uncertainties than we had back in 2004 or in 1999. We are somewhere in, my briefing here says in the middle of, I think that's probably optimistic, a major economic crisis. I hope that by the time this 5-year period is over, we're well out of it, but who can tell? So we have to take account both of the needs of the European Union in its travails today, but also as we come out of them and move ahead into better economic times. We are in a period of political uncertainty over the Lisbon Treaty as we write the Commission's proposal today. We don't know whether it will come into force or not. That depends on you, but not only on you. There are 4 member states still to ratify, as you're all aware. And there is, as usual, some political uncertainty about who may join the European Union. Can anybody really say how many member states there will be in 5 years' time? I can't. Will there be Iceland? Will there be Croatia? Will there be former Yugoslav Republic of Macedonia? Will there be others or not? Nobody knows. So we have to provide a proposal, and that's what the Commission is for, in the general European interest, looking ahead, lifting our eyes above the hurly-burly of national domestic politics. And that is what the Commission will set out to do in its proposal on Wednesday. Now, Nora said, and she's absolutely right, I don't know whether we are the most citizen-centred set of policies, but we believe that we are doing this for the citizens of our member states, and you will find a very strong emphasis in the Commission's proposal on that. The theme running through the text is how can these policies serve the citizens of member states of the European Union? How can they support other European Union policies in doing that? And how can they support national policies doing that in each of the 27 member states? And that theme runs through the whole document, as I said, and informs all of the specific policy areas. Taking them one by one. When one looks at migration policy, including in the general term migration, immigration, both legal and illegal, and asylum, we have built up a certain amount of common understanding, some common rules. Habits have grown of working together in that field. Perhaps more closely among the Schengen countries than across the European Union as a whole, but one can overdo that. In my 6 years in this job now, apart from what you do with the specific Schengen legislation, where you have to decide is this Schengen related or not, do the Irish and the British take part or not, apart from that, when considering the general issues of migration policy, there is very little difference between British and Irish interests and the interests of the continental countries which are part of the Schengen system. Schengen system, by the way, has grown a lot in recent years. Switzerland has now had its last, I hope, referendum clearing the way. Is somebody Swiss here? Right. Correct me if I get this wrong, but the recent referendum in Switzerland on biometric passports, which was won with the overwhelming majority of 50.14%, cleared the way, the last remaining obstacle for Schengen membership. And if you go, but well, not from here, but if you go from Brussels backwards and forwards to Switzerland, as many of my colleagues do, particularly to Geneva, it is now like going to Rome or Paris or anywhere else. So Switzerland has joined Schengen. The Principality of Liechtenstein is very close to joining Schengen as well. And as you know, Norway and Iceland are already in the Schengen area as well. Will there be in the next 5 years more Schengen members? I don't know about you and the British. That's essentially up to you and them, because you would have no difficulty in meeting the requirements. It's a political decision. Bulgaria and Romania certainly hope to join the Schengen area fairly soon. For them, it is a question of meeting the very severe requirements which the Schengen system imposes on them, and we hope that Cyprus will join as well in due course, but that country has its own domestic difficulties, as you know, which make Schengen membership rather difficult to contemplate in the immediate future. So, coming back to immigration and asylum, on illegal immigration, of which there is quite a lot, the media focus in recent months being on the Mediterranean, but one should not forget the Union's eastern borders, and one should not forget other ways of getting illegally into the European Union. There, of course, everybody agrees that illegal immigration should be prevented, and if not prevented, should be dealt with when illegal immigrants are apprehended within our territory. Dealt with in a decent, humane way and full respect to the fundamental rights of the people concerned, but also dealt with by returning people to the country they came from, if that is possible under international humanitarian law, And indeed, this is where it gets complicated, of course, if it is possible to identify the country they came from. One of the major difficulties in illegal immigration, particularly across the Mediterranean, is that people arrive in large numbers in Malta and on the Italian island of Lampedusa without papers, and it becomes very difficult without their cooperation, and without the cooperation a lot of the time of the embassies of the countries from which they may have come. It becomes very difficult to identify them and therefore to identify whether they have a reasonable asylum claim or whether they should be returned to the place they came from. Now, the place they came from, again, is easy shorthand. It's terribly difficult because usually, particularly from Africa, they have crossed thousands of kilometers of desert, usually at great risk to their lives, and reach us from the coasts of North Africa in recent years, essentially from Libya, but to a certain extent also from the northwestern part of Africa, Senegal, heading for the Canary Islands in Spain. Or another important route, Turkey, and that brings in a lot of Asian illegal immigration into Greece and the Balkans. What can we do about all of that? Well, we can do quite a lot by working together. It doesn't require a great deal of legislation. We have a famous return directive organizing the way in which persons illegally present in our territory should be returned. But most of the time, it's operational cooperation between the border guard forces of our member states. We have an agency which helps in the organization of that practical cooperation called Frontex. It's in Warsaw, although most of its activities in recent years have been in the Mediterranean. And the real answer to the often tragic situation of illegal immigration to the European Union is, of course, cooperation with the countries of origin, the countries of transit, in order to stop it happening in the first place by explaining the dangers of embarking on this journey, by explaining that our streets are not paved with gold, by explaining that far too often people fall into the hands of traffickers using their entire family savings, only to end up either dead in the Sahara or dead in the Mediterranean, or sold into some form of exploitative slavery in the European Union, or, with great respect to the great Republic of Malta, stuck in Malta, of which many of them had not heard. The hope setting out across the Mediterranean is to get to Italy. Some want to stay in Italy, some want to take advantage of the fact, of course, that Italy is joined to the rest of the European continent to move north. Malta, people are stuck. It's an island, or it's a group of islands. And Malta is bearing the brunt, essentially, of a great deal of illegal immigration across the Mediterranean. Malta, as I'm sure many of you know, has spent the last 50 years in a great internal debate about whether to join the European Union or not. They finally do. And the one unexpected consequence, which has been the major political consequence for that country, has been illegal immigration from Africa. So we need to do a lot of things. We need to work with the countries of origin and the countries of transit. That raises all sorts of delicate issues about our relations with Libya, which have had ups and downs. What it really means is that Europe has to run its diplomatic effort in a coordinated, joined-up way. We do some of the time. We should do it better. And we, up here in the north of Europe, should not think for a minute that this is a problem for the southern European countries only. We have our own problems. It's easy to understand that attitude, of course. But they don't want sympathy. They don't want solidarity. They don't even want money as an illustration of what is called politely burden sharing. They need a common understanding on the part of all of us that this is a European problem. It is a European problem. The countries of destination are in the north of Europe, not in the south. The Maltese Minister of the Interior told me recently that the most popular language, the Maltese provide language lessons for people in the reception centres for immigrants in Malta. What do you think the most popular language people want to learn is? Well, the answer is Swedish. Swedish, why? Because it's a beautiful language, of course, but also because Sweden, long way from Malta, has a reputation for being quite liberal in its immigration and asylum policies, a justified reputation, by the way, and is also a place where many of these people have family or at least diaspora communities into which they think they could integrate quite easily. So a lot of work is being done on illegal immigration. It is often seen, and of course it has many manifestations, as a purely local or national issue. It's a European issue. It's a European issue, one which calls for practical cooperation measures between member states, uniting diplomatic clout, uniting values of the humanitarian welcome we give people who deserve it. Leads me to asylum, I'll come to that in a minute, but above all requires us to think of it as a common European issue, to be distinguished clearly from free movement among the member states of the European Union, of course, and I'll come back to that when I talk a little bit about citizenship. Legal immigration. Legal immigration is a completely different matter, largely within the competence of the member states, different policies followed by different countries, a certain amount of European legislation to bring about a common approach to certain issues of legal immigration. It happens. We need it. It will not go away. It will seem to be a luxury and unnecessary in parts of our economies as we grapple with the challenge of high unemployment in the next year or two. I hope no more than that, but who knows? So in the economic crisis. But the fact remains that parts of our labour markets call for immigrant labour. They call for it in an uncoordinated, illegal, exploitative, unofficial way, and we all know that happens in our countries, and they call for it in an organised way, and each of our member states is feeling its way towards different systems for organising legal economic migration. Of course, the difference between our countries is considerable. There are countries with large agricultural sectors needing seasonal workers. Who picks grapes in Spain, olives in Greece, and so on? Seasonal workers coming from other parts of the world, largely from North Africa, in the case of France, Spain, to a certain extent Italy as well. That's, if you like, at the unskilled bottom end of the labour market. At the top end, just to choose another example, we are short of people to run our health services. We are short of certain types of computer programmer. There seems to be a disconnect between our education systems and the needs of our labour market. And of course, there is a long lag between trying to fix the latter to serve the former. So those gaps, those needs, again, are filled by recourse to immigrant labour. The question is, question for the European Union, should that be done in simply 27 different ways, responding to the needs of each of our countries' different labour markets? To a large extent, probably yes. Is there a good argument for a coordinated approach in some respects? I think yes, too. And so in addition to the body of legislation which is already in place, I imagine that in the next 5 years we will see more work being done on these issues as well. There is a link between the two. A link between the two which we are not very good at making, because the countries of the European Union which have the most successful national immigration policies quite deliberately link the two by going to countries from which illegal immigration takes place and saying, I want to talk to you in a serious grown-up conversation about migration between our territories and our economic relations more generally. So you will find, for example, the Italians going to the Albanians, going to the Egyptians. You will find the Spanish going to the Senegalese and saying, I have a wide palette of policies. I don't want illegal immigration, and I think it's not in your interest to allow often your highly educated or your able-bodied young men and women to leave the country in conditions of great danger on this journey north. But I'm honest, I know that we employ a lot of these people if they make it to our territories. Let's talk about legal immigration. Let's talk about quotas even. Or some do it through a point system, some do it through quotas. And throwing into the mix targeted development aid, targeted assistance to run the border on the other side of the country. Why is Libya such a source of illegal immigration to the European Union? Because Colonel Gaddafi, in his wisdom, announced a few years ago that all his African brothers and sisters were welcome. And the southern Libyan border, which is thousands of kilometers of desert, is very difficult to manage. Does Libya want assistance in managing that border? More and more it does. What does that assistance mean? It means training, it means procurement, it means equipment, it means targeted aid, it means setting up an asylum system, and so on. So all of that can be done, is done at national level. I leave the question with you, should that be coordinated better at a European level? Frankly, today it is not very well coordinated at European level. And it is only in recent years, I think, that in our member states, people have begun to make real the links between those various policies. Asylum is a fundamental right. We are proud of our values. We are proud of our humanitarian traditions. All of our countries are. We have, each of us, national asylum systems. We are all party to the international legal rules which underpin the asylum system. There is a certain amount of European legislation in place providing for common rules. That work will continue. It is controversial, not in substance, but at the margins of how far one should go. There are controversies. This is not the best economic climate in which to promote a generous asylum system. We realize that, but we will continue in the coming years to promote common rules on asylum among the European countries, including the Dublin system, of which you should be proud because it bears your name in the city, which provides for a system under which one applies for asylum in the first member state in which one sets foot. And we have a whole database called Eurodac containing fingerprints of asylum seekers to make those decisions easy in real time. I'd like to turn now to developments in the justice area. We have today, essentially, simplification, civil law already under co-decision, qualified majority voting in the Council, normal jurisdiction of the Court of Justice, and criminal law, quite different, unanimity in the Council, no Parliament, no Court of Justice. First pillar, third pillar. The Lisbon Treaty would dismantle the pillars. It would not make everything that's today in the third pillar exactly the same as everything today that is in the first pillar, because it will bring with it various safeguards essentially designed to make sure that the differences between our legal systems are not threatened. I know that's an issue which has sometimes had its importance here. We now have 27 member states. We used to, again, it's a caricature beyond even a simplification, we used to have Napoleon and the common law. Now we have all sorts of different legal families, and by the way, the common law family is bigger than it used to be. It used to be only the UK and Ireland, but we now have Malta and Cyprus as well, and they do coordinate those four. It's one of the many sub-27 groupings that the European Union has spawned, because I dare say it's the only way in which practical business can be conducted now. There are geographical groupings, of course, and there are affinity groupings of that sort, and there are size groupings as well, the ones that think of themselves as big, coordinate with each other, the others which resent the fact that they think of themselves as big coordinate as well, with all sorts of difficulties about who is almost big but not quite. What about the Netherlands? What about Spain? The famous G5 group is now 6 because Poland is in there. The Dutch are not, all very delicate. And we will have no doubt to carry on living with issues like that as long as we make sure that the Council, where all 27 are, remains the focal point of member state activity within the European institutions. I think we will be okay. So, we have a great deal to do. Again, to simplify, what will Stockholm say on both of those things? On the civil law side, what Stockholm will say is that there are 8 million, there's no precise figure, Europeans living in member states other than their own today. It's 28th member state, larger than some of the 27, obviously, many of them. Those people who are moving around the European Union should be served by the European Union's justice and home affairs policies by making events in their lives less difficult than they are today because of the obstacles raised by the different legal systems. People move around the European Union. They have children. They have to give names to their children. They get married. They get divorced. They die. They have wills. In all of those areas, life is already pretty complicated, even if you marry the girl next door and you never leave your hometown. Once you move to another country, obviously the obstacles are greater. We want to make things as easy as possible, not by having one great glorious European civil code, which we would never achieve anyway and would spend 200 years failing to do, but by providing for mutual recognition. Sounds easy. What happens here should be recognized and enforced there. Of course, the detail is diabolical, and it requires, that mutual recognition requires two things. It requires mutual trust between our legal systems, not always self-evident, and, this is where it gets controversial, it requires a certain degree of common rules. Therefore, the dread word harmonization comes in. To what extent is it necessary for the legal systems to share common definitions in order to provide for mutual recognition to work? And that issue arises both in the civil field, in respect of persons and in respect of companies, and in the criminal field, where mutual recognition, again, is the name of the game. We don't want to have a European criminal law. We want the 28, mustn't forget my Scottish compatriots, legal systems to work together in as seamless a way as we can, respecting their specific characteristics. Each country thinks that its civil code or criminal code in the countries where they have them, is the flowering of their national genius, and no doubt it is, and everybody therefore thinks, and lawyers tend to be conservative, that their system is better than everybody else's, and that any change can only be for the worse. If everybody sticks to that position, we're not going to get very far. So mutual recognition is the key. The Stockholm Program will say that again. Not terribly controversial as a general idea, of course, but what is controversial is the way that principle is worked out in specific issues. The great achievement of the third pillar in the criminal law has been the European arrest warrant. It was adopted in extraordinary political circumstances soon after the tragic events of 11 September 2001. It's interesting to speculate about what would have happened if 9/11 had not happened. Would we still be debating it? I don't know, probably. But you can ask me that question when the cameras have turned on later. But it is the best example of third pillar legislation actually working. It works, courts are using it all the time, some too much. We had a big debate in the Council of Ministers in Luxembourg on Friday on how the arrest warrant is working, and it's a remarkable thing to be able to say. The real complaint is it's working too well. People are using it too much. People are using it for relatively insignificant low-level crime, and so the system is getting clogged up. Well, that's frankly a problem, but a problem I'm happy to have because it's one for adjustment. The real story is that extradition between our member states is a thing of the past. We even got rid of the word. We surrender people from one jurisdiction to another within the European Union because we have some common features and some common challenges. Everybody has understood, I think, that many crimes are international, that a national criminal justice policy cannot operate in isolation from the others, particularly in an integrated economy and an open territory of the sort that we've created in the European Union. And that has not only survived, but has been robust enough to encompass enlargement of the European Union, now 27 countries, since 2001, of course, and works daily. Extradition has been depoliticized and is now a judicial system which works extremely well. I'm putting a lot of emphasis on the arrest warrant because it is the best we have done, but frankly, it is by far the best we have done, and a lot of other third pillar legislation is less satisfactory. We have, alongside the European arrest warrant, we had the ambition to have a European evidence warrant, which would allow for easy transmission of evidence from one jurisdiction to another. There is legislation on the European evidence warrant, a framework decision, which is the third pillar equivalent of a directive, but frankly, it is, in our view, not a very satisfactory piece of legislation because it was diluted so much in the debates requiring unanimity at the end of the day that it ended up falling far short of the Commission's initial ambitions. Maybe we were wrong, maybe the Council was right, but I'm giving you our view. Also, alongside the European arrest warrant, there should be a common EU system guaranteeing procedural rights for defendants and suspects. Is there? Yes and no. There is, of course, the European Convention of Human Rights, and all of our member states are highly developed democracies which respect the rule of law. So we have the European Convention, we have our national constitutional traditions, written or not, and we have the Charter, which is out there, promulgated, and will be given force under the Lisbon Treaty. But we don't have a dedicated piece of legislation. We have tried, but requiring unanimity, what actually happened was we, through lengthy process of discussion in the Council of Ministers, diluted it to a very large extent and still hit a brick wall at the end of the day about its precise scope and important issues, I fully recognize, of legal authority, of competence to do it or not. And so far, it has not succeeded. The Commission intends to make a new, much more limited proposal very shortly, and the Swedes say that they will work very hard to get it enacted under their presidency. That is pre-Lisbon. Under the current system, we are still trying to get unanimous support for a more limited in scope piece of legislation on procedural guarantees. Under Lisbon, of course, that would become possible under qualified majority voting and with the Parliament, but we accept, at this stage at least, that something of that importance should really be done with the support of all member states. We don't think at this stage that it's appropriate to wait and force a vote. So that will come. It's important because despite all the great politics about mutual trust, the fact of the matter is that mutual trust between our legal systems is not as profound as it could be. And that Europeans from one member state arrested in another don't always feel as comfortable as they would at home, if only because the language is different, the laws are different, the procedural arrangements are different, and they feel that they're not quite sure of the rights to which they're entitled. We want to address that issue above all. We want European judges to trust each other, we want European lawyers to trust each other, we want European citizens, when moving around, if they get into trouble, to feel that they are being dealt with as fairly as they would be at home and as they would expect their own legal system to deal with other Europeans back at home as well. So we'll do all of that. I don't know whether it will all come to fruition, but more work will be done. Now, what will happen in the coming years? Crime will continue. Crime will continue to be international. Drug trafficking will continue to be international. People trafficking will continue to be international. Prostitution will continue to be international. We have to face these challenges together. And the way Europeans have decided to face these challenges together in the early 21st century through the institutions and the rules that we have created together. And they, I hope, will be the Lisbon ones. Today they are the Nice ones. They are not perfect, but with goodwill, and there's an enormous amount of goodwill out there among politicians, among parliamentarians, among the actors in the legal systems, the rules can be made to work. Most of the time they do. There is a good story to tell for the European citizen. His or her, our security does depend on our police forces working together, our courts working together, our borders being managed collectively, whether in Schengen or not, but again, in particular, in respect of the Schengen countries. Now, fundamental rights, and I will finish on this issue. Fundamental rights are obviously at the heart of everything that we are doing. These are not just words. The European Union is based on a set of common values. It's based on a common understanding of all the horrors of the 20th century in our countries, and are turning our backs on that past while remembering and understanding and trying to build something new. Initially, the small group of countries in the 1950s with, in a way, the most immediate experience of the Second World War, but now spread essentially to the whole of the European continent, if you include Schengen, really most of what we think of as the European continent today. And that is based not only on economic growth and jobs and the importance of trading with each other, it's also based on a common set of political values: democracy, the rule of law, the independence of the judiciary, and so on. These are arguments that we have made successfully. We didn't have to make them very hard to our new member states as they transitioned to democracy, and it is the main argument that we are making today to those countries still knocking at our door, particularly in the Balkans. And that will continue to be the case. But fundamental rights are not just an aspiration or a speciality of international lawyers. They are a concrete part of our legal systems. Each country has its own national way of doing it. We have the Common Council of Europe, European Convention system, and, as the lawyers amongst you know, the European Court of Justice has developed, using both of those traditions, the common constitutional traditions of the member states and the European Convention, has developed its own way of protecting our fundamental rights in circumstances in which EU law is being applied. All that will continue. What difference will Lisbon make? Two. It will allow the European Union to accede to the European Convention of Human Rights. Hitherto, that has not been possible for legal reasons. I expect that the European Union will, can't tell you when or whether, even because those are political decisions ultimately, but it is widely expected the EU as such will become a party to the European Convention of Human Rights, which will mean that the European Union as such will be called to account in the European Court of Human Rights, and that is a missing gap which will be filled. Very important. Secondly, the Charter will be given legal force, subject to special arrangements for certain member states. And I think we now have, in addition to the basic treaty rules which provide for the commitment to fundamental rights and a mechanism for dealing with member states which flout them, we hope never to be used, of course, we have a full range of protections of fundamental rights. That means a number of things. For technical lawyers, it means that there is an answer, I hope a definitive answer, to the legal systems and the constitutional Supreme Courts of member states who worried that the EU did not provide as complete a system of protection as its system did in its national context. I hope that that conversation, which will continue, of course, on detail between the European Court of Justice, the European Court of Human Rights in Strasbourg, and the national Supreme Courts, will not be as difficult as it has been as the EU system was catching up. And it sends a message to the rest of the world about who we are, how we do things, what we believe in. This is not another speech at the General Assembly of the United Nations. This is a range of legal commitments and mechanisms for the vindication of rights, which we all have. And if the system works as it is designed to, it will mesh the specific national systems, such as you have here and other member states have in their different ways, with an overarching European commitment. And that should be to everybody's benefit. So I haven't come here to plead for the Lisbon Treaty. I've come here to say how, in some respects, the Lisbon Treaty will change this growing policy area. To sum up and simplify, the pillar structure will be abandoned, which will make the system easier to understand. Today, frankly, you have to be a pretty sophisticated lawyer to understand what we call in Brussels sometimes the pillar talk between first and third. We will still have the equally arcane science of Schengenology, working out what is Schengen and what is not. Are the Irish and the British involved, or are the Swiss involved? That will continue, but we have always found pragmatic ways to deal with that until everybody joins Schengen one day, I hope. That will continue. The human rights protections will be improved. The treaty will bring with it a number of specific arrangements negotiated by particular member states. They will be applied. It will bring with it the emergency brake system to send something up to the European Council if a member state is particularly alarmed about the impact on its legal system. Again, I would hope that issues could be discussed, sorted out before that emergency brake is pulled, but if they're not, it will be, and there's a system provided for that. So the treaty will make the system more accountable, European Parliament far more involved, more legally accountable. The Court of Justice's jurisdiction will be extended largely to the whole area, and the court has special accelerated procedures already in place to deal with cases which have to be decided quickly. And the Council will no longer, in most cases, be subject to the unanimity rule because qualified majority voting will be the general legislative procedure. If all that happens, but frankly, even if it doesn't, I have no doubt that Justice and Home Affairs will continue to be an important policy area for the European Union, and everybody will be surprised that we didn't do this from the very beginning, because crime is international, borders are obviously international, because our legal systems have to work together, there have to be mechanisms to provide for that. It's not enough just to say it. That is what we have been doing for the last 10 years fairly intensively, and I'm sure that work will continue in the coming period. I'd be happy to answer your questions.